Those of you that want to continue to eat, those that want to talk, it's just not talk for a few minutes. It's our pleasure today to have Mike Hunter, who's our Attorney General of the state of Oklahoma. For many of you that may remember, Mike made a presentation to ACCO board back something like 8 or 9 months ago. And he has had some breaking news as far as the settlement regarding the opioid lawsuits across the state. But Mike comes with a real blue ribbon past as far as this room is concerned. His father was the foreman for the county commissioner in Garfield County. So he also served in the legislature. And we're really proud of the fact that he's here today. So we're going to give him a few minutes of your attention in order to discuss the settlement and some thoughts that he's got about it, how we may fit into as far as the settlement is concerned. So if you will, let's give our attention to Mike Hunter, Attorney General of the state of Oklahoma.
Well, thank you all. As Gene said, my dad was county foreman in District 3 back in the 60s, so I have some familiarity, and having grown up in Garfield County and watched my dad go off to work, and sometimes he would take me with him. That's certainly left its mark on me as somebody who appreciates just how important the work you all do in the counties is. The thing I'd like to share with you today is, as you all know, we are in litigation with opioid manufacturers down in Cleveland County. There were 4 defendants. As Gene said, we reached settlement with one of those defendants. It was a very delicate exercise. One of my colleagues in the legal team referred to it as high-stakes poker. I don't gamble, but that certainly framed it in a way that underscored just how sensitive those negotiations were. So Purdue Pharma, which is probably the most notorious of these defendants, is an unusual entity. It is closely held. It's privately owned. They are the defendants in well over 1,000 lawsuits around the country. And if I was their lawyer, I would certainly be counseling them to, and would have been counseling them to carefully consider bankruptcy as a way of managing their exposure to these lawsuits. So as we were in negotiations with Purdue and some of these other defendants, Purdue's admonition was consistently, we're not going to go to trial in Oklahoma. And of course, the inference there is the closer we get to trial and we don't have a settlement, the more likely it is we're going to declare bankruptcy. So as we began to spend time with the company, and I just really have to take my hat off, if I was wearing one, to the great legal team, because the reason that they were at the table and the reason that they were seriously in negotiations with us is because we've been beating the snot out of them for the last 20 months. Okay, hundreds of depositions, I don't know how many millions of documents that we've reviewed. So we had a good handle, and they knew we had a good handle on their exposure in the state. There were all sorts of, I don't want to call them threats, but there were all sorts of directives that in addition to saying we're not going to go to trial, the other thing they said is we're going to talk to the other attorneys general and they're going to run over you, Hunter, so just be prepared for that. Well, that didn't happen. So as they began to take inventory of the exposure that they had in this lawsuit, it's going to be live television. It's going to be filmed. It'll be on national television. What they really want to do is they want to have a program bankruptcy in connection with the multi-state process, which is occurring in connection with a lot of my colleagues around the country. They want to have a program bankruptcy, put a bunch of money on the table, and save their business model. But this trial stood in the way of that. And so as we spent time and as we pushed hard, and understand this, the mediation that we were involved in, the negotiations were overseen by a former federal judge, Lane Phillips. So he was going back and forth between us and the parties, and we got to a point where Purdue said to us, you know, tell us a way that we can distinguish between a settlement that we're going to make with Oklahoma and something that we're going to have to use as a modifier, as a multiplier for all these other states. And so the approach we took is we think that you can settle with Oklahoma, but it'll be a settlement of national importance. And so the sort of the obvious footprint in the state, as we looked at ways to do that, was the OSU Center for Wellness and Recovery, which was stood up a couple of years ago. They've already got, I think, almost $5 million in grants. But their focus is addiction science. You know, what's the best science? What kind of research can we put to getting people over their addiction? So as we begin to focus on that, again, as a way for them to separate Oklahoma from what they may be forced to do with other states, we really were able to get some momentum behind those discussions. So the commitment that Judge Burge and I have made to you, and the follow-through, if you will, because of, you know, there's a lot of comparison between the tobacco settlement and this one. And as we all know, political subdivisions got this much. Back in the tobacco settlement, well, there's a down payment, you know, and it's certainly not a ton of money, but I want everybody to understand that that's a down payment on what we hope will be a really material fund that will assist political subdivisions, cities and counties around the state. So that settlement was for $270 million, $12.5 million has been set aside. The important thing, I think, for everybody to understand here is that we've still got a lawsuit to try. And we are confident in our case. We are confident with respect to these defendants that we can demonstrate that they are responsible in large for the epidemic, thousands of deaths, thousands of overdoses. And as one of my colleagues on the legal team said in court a while back, you know, there's this great book, Things I Learned in Kindergarten, and one of the most important things is when you make a mess, clean it up. So our goal is to compel these defendants to help us clean this mess up. I want to just reassure everybody, some counties, some cities are represented by law firms. We're working to align our interests with those law firms, continuing discussions. I've been very clear with political subdivisions that that's a decision that you make with regard to outside counsel. We respect that, and we're again hopeful of really having a united front as we move into this case. But again, the goal is, and the commitment that we made to y'all, I guess a little over a year ago, is that there will be a set aside, there will be a material effort with respect to any kind of judgment or settlement that we enter into. Don't really expect any settlements to occur prior to trial at this point. As President Kennedy said, never negotiate out of fear, but never fear to negotiate. So I'm not saying there's not going to be an opportunity for another settlement. But right now, it looks like we're going to trial on May 28th with these additional defendants. So I wanted to share that report with you, and I'm happy to answer any questions, Gene.
Well, I think the obvious first question is, what are the options for the counties that may or may not have legal counsel as far as the initial down payment in some?
So what we've done with regard to this fund is the options are very flexible, and it's really up to cities and counties. Once we come up with, and you know, we've got a group of I think very fine lawyers who, in sort of an informal way, are overseeing this fund. But it's important, I think, to get a formula, to get some kind of an approach to how allocations are made, because you know we don't want to have disputes between municipalities and counties. We want municipalities and counties to work together, and that formula approach is real important, and we're just getting started on that. And commitment we have is General Turpin is chairing that group, The Tulsa City Attorney, Dave O'Melia, is involved. Very fine lady, former assistant AG, who's active in a lot of charitable work in Oklahoma City. Tricia Everest is involved. And then David Weatherford, who represents a lot of cities and counties. And then Greg Mashburn, who's the DA down in Cleveland County. And that group is designed, again, to represent cities and counties with regard to the formula, and for those cities and counties that have law firms, to work with the law firms to come up with a formula that makes sense for everybody. But I just want to reassure folks, I'm not compelling anybody to participate in this fund. You participate in it based on the decision that you make. No releases are going to be generated by my office. I don't have the authority to enter into releases on behalf of counties. I haven't undertaken that. I don't have the authority with respect to sales tax that y'all generate, nor do I have the authority with regard to ad valorem money. So that's the line that I've drawn. I just want to be clear with everybody. There are no releases in place, and there will only be participation if you opt in. And again, it's intended to maximize the options that you've got with regard to, again, the law firms that represent some of you, as well as the decision you make with regard to the fund. But I think it's very important, again, to spend time to make sure that we get allocation methodology in place so that there's not disagreement and acrimony when distributions begin. But again, we've got to win this trial, and I can't be more confident about the case that we've got, but winning this trial, getting a judgment in place, and getting these people to pay us what they owe us is the long-term goal. Yes, sir.
I mean, on the upcoming trial with the rest of the pharmaceutical companies, are you pushing for a bench trial or for a jury trial?
So we made the decision based on a lot of different vectors that we needed to bring our best case to trial. These defendants have done everything that you can imagine to try to derail this lawsuit, and we were being deluged by a lot of pre-trial stuff. So we opted to focus on the public nuisance cause of action. It's our strongest. It's got the most potential for recovery with regard to what we need to abate the epidemic. And that trial is going to that is going to be a bench trial. Judge Bachman is going to be hearing the evidence in that case. And what that does is it avoids a lot of the pre-trial nonsense with regard to defendants wanting to control evidence, wanting to limit testimony, because when the judge tries the case, those are decisions that he makes in real time. So Judge Bachman's going to try the case.
So there wouldn't be any chance of any kind of like punitive monetary damages then that would be that we would see as a state.
So we believe that our damage model with regard to the public nuisance is in the tens of billions of dollars. And so that's what we believe our evidence is going to show the judge.
General,
Yes.
when you say opt-in, are you saying each county needs to opt in on this second phase of this? Do I understand that right?
So once we get the whole thing funded, I mean, my goal would be, again, that working with stakeholders, cities and counties, that we come up with an allocation plan. And so the down payment, if you will, the $12.5 million is in the state. It's in an account, being held. Future judgments and/or settlements will go into that fund. And then decisions about whether folks participate in that or not, those are decisions that you're going to make either as a county or in consultation with your lawyers.
So we've chosen other counsel, so do I need to do something different going forward?
Now, if you retain law firms, you need to work with your firms. Our expectation is that we'll be able to work with your firms to make the best decision for you. But you've chosen lawyers, we respect that. And our commitment is that we'll work with your law firms.
And it won't hurt me or help me to stay with this firm that I'm with?
Not as far as I'm concerned. The commitment I made to everybody is if you feel like you need to go out and retain law firms, that's your decision. And I'm respectful of the body politic within counties and municipalities. And so I haven't, in fact, I've respected that, I think, the best that I could. Yeah.
I know when he was here before, we just brought it up, and money would be coming
So, just to be clear, I've been, I think, respectful of decisions that are made by cities and counties to hire outside firms. And so in that case, we're going to work with your law firms, you know, as part of the process of coming up with an allocation. If you don't have attorneys, I would imagine, you know, from the municipality standpoint, we'll deal with the city attorney or your district attorney. Yeah. Question there in the back? Halfway back, excuse me.
Is there any kind of concern that as these companies are potentially declare bankruptcy, is the state going to be on the hook to take these funds that are supposed to go to build the facility, which OSU's wanting to use?
Yeah, so we've got those monies escrowed, and the approach that we've taken is there's a 90-day clawback period with regard to the filing of a bankruptcy. And so none of those funds are going to be expended. We've still got to set up, with respect to the OSU Wellness and Recovery Center, there's got to be a foundation that's finalized, and you know, we've got to get the IRS to sign off on the paperwork. But our approach is just to ensure that we're not exposing anybody to clawback, is none of those funds are going to be expended until that 90-day bankruptcy clawback period runs its course. And so we're about a month into that. But with regard to Purdue, we don't really see any vectors, any negative vectors. The next trial beyond ours isn't scheduled until the fall. So we're very confident that we'll get through that 90-day period and then not have any bankruptcy clawback issues. The other companies I think are very solid. One of the companies has a lot of debt, but they've all got a pretty strong market cap. They're publicly traded, and it's just much more complicated when you're a public company to declare bankruptcy. So we're confident that we're not exposing the state to any you know, requirement to pay money back. That's how we're managing the funds right now. Good question. Anybody else?
Well, just one suggestion on as far as like the 12.5 million, talking about municipalities and counties and everything. You could block grant it to the counties, and the county commissioners, the cities would have to come to the county commissioners to decide what they, you know, what their amount of is. Just give suggestions.
That's an interesting idea. Anybody else before I get out of your hair? Well, listen, thank you all for your support, and thank you for giving me an opportunity to visit today, and I'll let you get back to business. Gene, take care of yourself.
We're getting ready to break and go into our ACCO board meetings. We appreciate everybody's attendance